All right, everyone, good morning, or now good afternoon. Today is Tuesday, December 2nd, 2025, and the Wake County Board of Education work session will come to order. Today we have two items on our agenda, the employee ombuds policy and the international exchange student policy. Then, depending on what time we finish, we may go into a closed session just to try to move some of our closed session agenda items off our calendar a little bit earlier before our meeting. At this point, I'm going to recognize Dr. Crane and Neil Ramey to take us through the ombuds policy. We went through the presentation at the policy committee meeting, and what we did not get to is really review the actual draft. So the draft language is in Assembly for you if you want to pull that up, and I'll turn it over to either Dr. Crane or Mr. Ramey.
This presentation is also provided as backup information in Assembly. When we overviewed it, we kind of gave the historical background, what an ombuds does, maintain a neutral role, receive complaints, provide information, supports informal dispute resolution. Informal is a key word there, and identify and report recurring issues to inform prevention. How might they report that? I think I referenced the International Ombuds Association has uniform reporting categories here. I've got a copy of what that looks like. So this is one way that can be reported, what is coming in as a dispute or complaint or request for information. How might that get reported out? This is one way that can happen. What does an ombuds not do? They don't accept claims. They do not conduct formal proceedings. They do not conduct formal investigations. They don't make decisions, and they don't advocate. This is a neutral position. The core values of an ombuds: act with honesty and integrity, promote fairness and support fair process, remain non-judgmental, with empathy and respect for individual differences, to promote dignity, diversity, equity, inclusion, and belonging, endeavors to be an accessible, trusted, and respected informal resource. There's that word again, informal. Communicates accurate understanding, and then promotes individual empowerment, self-determination, and collaborative problem solving. The four fundamentals of an ombuds practice are independence, in that they are not aligned with either the formal leadership of the district or the employees. We're talking about employee ombuds here. They are impartial, it is informal, and it is confidential. There are some exceptions to that regarding mandatory reporting requirements. Those are addressed specifically by policy, title, and number in the policy. And so I'm going to back up to this slide. We made it through these prior, but I'm going to leave it here, and then I'm going to turn things over to Mr. Ramey, who's going to walk you through the policy draft. The policy, as I understand it, establishes the guidelines for the responsibility and responsibilities of a Wake County Public School System employee ombuds. Again, this isn't just an employee ombuds policy.
You mean the ombuds for employees?
An ombuds
Yes.
for employees, yes.
Thank you, Dr. Crane. So I'll just walk you all through the section by section like staff normally do, since I actually drafted this policy. It is based on the history of the policy. It is based on very closely on a policy that I developed for Orange County schools, which in turn was based primarily on a policy for the Pasadena, California school system. But in working with Orange on this, we reviewed, I think, 5 or 6 different school board ombuds policies and kind of drew from the best from most of them, from all of them, mostly from the Pasadena policy. That's where this came from. And you'll see as we walk through the structure and content of the policy that it aligns with the general principles that Dr. Crane just summarized, which are all from the International Ombuds Association. So the idea is we're not reinventing the wheel here. This is a fairly defined role. We're also not planning to change your current policies on investigations and appeals. You already have very formal processes that align with state statute, in some cases federal statutes, say with Title IX. So there's no change to any of that. This is an overlay, an additional resource for employees, a confidential resource for them to call, Zoom in, have an in-person meeting with to talk through their issues, see how they might be able to address them successfully through formal channels, or if necessary, here's your grievance policy, you can pursue grievance. So starting with the first section of the policy, section A, purpose, the first sentence may be the most important in the policy. It gives you the general purpose of an employee ombuds. So I'll just read that. The purpose of the employee ombuds is to provide school system employees with access to an independent, impartial individual who can help facilitate a confidential and informal resolution of concerns, conflicts, and issues arising within the Wake County Public School System, and who is authorized to bring systemic and organizational concerns to the attention of the superintendent and board of education. And the consults are confidential, but the ombuds would be reporting to you on any sort of patterns or systemic issues that the ombuds identifies. This section of the policy goes on to explain that ombuds consultations are not a substitute for any mandatory reporting requirements. So, for example, any crimes against minors, child abuse, seclusion and restraint, these are all things that have to be reported, and calling the ombuds does not discharge those responsibilities for your staff. It also explains that the policy is not a replacement for formal complaints and grievances. For example, a racial discrimination claim, there's a very formal process for an investigation, written report, and appeals from those things. So this is not intended to supplant any of those formal procedures. This section of the policy emphasizes that ombuds services are entirely voluntary, so no employee can ever be told you must check with the ombuds, or it can't be a required step for resolving any concern. This section also notes that the ombuds guidance to individual employees does not create enforceable rights or bind the school system. So the idea here would be, if we hope the ombuds would be very careful in reviewing policies and such, and giving good, accurate guidance to employees, if the ombuds were to make a mistake, that doesn't bind the board. So, for example, if an appeal comes to you in a formal setting and you notice in the appeal there's reference to an ombuds consultation, the ombuds got something wrong, you're not stuck with the incorrect interpretation that the ombuds gave you. You still apply your policies as you see fit in consultation with legal counsel. And then finally, this section notes that the ombuds is subject to the International Ombuds Association Code of Ethics, which really is kind of outlines these principles that Dr. Crane has on the screen. But to the extent there may be any conflict, just in case there's a conflict, I don't believe there is, but if there were a conflict were to arise, the policy trumps the international code. That's Section A. Section B describes the scope of authority and independence of the ombuds. And it's very important that the ombuds not be subject to any undue influence. So in this section, the policy emphasizes that the ombuds works independently, is not subject to control, limitation, influence, or interference by any administrator, other employee, or even a board member. We're very specific about that. Nobody tells the ombuds how to do their job. The ombuds is acting independently and in good faith. However, the policy does acknowledge that the ombuds is subject to supervision by the superintendent and the board for budgetary, and evaluation purposes. So in terms of funding the efforts of the ombuds, or determining if the ombuds is doing a good job, if a contract should be renewed, those are valid ways for you to oversee the ombuds. This section of the policy notes that the ombuds is also subject to board policies, just like your employees are. So, for example, anti-discrimination harassment policies, the ombuds has to comply with them, same as everybody else. It states that the ombuds must remain neutral and can't hold other positions in the school system or elsewhere that would compromise his or her independence. So we don't want any sort of conflict of interest in dual roles. It notes that the ombuds can't make binding decisions, adjudicate disputes, participate in formal investigations or formal grievance complaint resolution processes. Again, the ombuds is an independent advisor and can help facilitate informal resolutions. The ombuds is not a mediator or an arbitrator, not an investigator. The ombuds doesn't take an issue and run with it and decide the outcome. The section of the policy also notes that the board determines the level of funding and support after receiving the recommendations of the superintendent. Again, it's a valid way that you oversee the ombuds, is budgetary. And there's language here that preserves flexibility as to who the ombuds is. So the idea, Dr. Taylor's planned approach is to hire an independent contractor, at least initially, to serve in this role. And I think the idea there is That's an extra layer of insulation. When this is a new concept, employees maybe have a little more peace of mind. This isn't even a school system employee. But really, you'll see organizations do ombuds both with independent contractors and with employees. It can work both ways, and the Code of Ethics allows both approaches. It's just important that whether the person is an independent contractor or an employee, they are outside the normal chain of command in terms of their consultations with the individual staff members, that they're not subject to someone telling them how to do their job on a day-to-day basis. So you could do it either way, and the policy preserves flexibility so that you can start, I think the plan is start with an independent contractor. If you decided to shift gears, you wouldn't need to revise the policy. That's it for Section B. Section C is about protection from retaliation. It prohibits retaliation against the ombuds by anyone who may be the subject of a complaint. Say an employee comes to the ombuds and talks about concerns about a supervisor. The ombuds advises the employee they can file a grievance, and now the supervisor is upset at the ombuds. Well, that supervisor is prohibited from retaliating against the ombuds for giving impartial advice to the employee. And this section of the policy also states that only the board, to again, protect the ombuds and the integrity of the ombuds office, states that only the board can demote, reassign, or remove the ombuds from office. Regardless of whether this is an employee or an independent contractor, the superintendent can only offer recommendations on the employment or service contract. The board makes the final decision. Okay, so that's another additional protection for your ombuds. Section D talks about the standards of practice. Again, it's pretty closely parallels the International Ombuds Association Code of Ethics, Part 1, but we've added language to address some issues that arise under state law. Part 1 is about the receipt of concerns and confidentiality issues. It states, reiterates that services are voluntary. Anyone may suggest an ombuds consult, but no one may require one. It notes that the ombuds may not communicate with board members or staff who refer someone to the ombuds about what was discussed. That remains confidential as to the person who met with the ombuds. So again, the only information that the board and the superintendent would get about the consultations is a quarterly report or supplemental reports that the board may request that do not identify the individuals, but that do identify systemic issues, trends, organizational concerns that you need to be aware of. And that's to protect the integrity of the consultation process so employees are comfortable to fully disclose their concerns to the ombuds. This section of the policy also authorizes the ombuds to consult in person, virtually, by phone, or in writing. That's something the ombuds can work out directly with the employee. It emphasizes that consults are confidential to the maximum extent possible and allowed by law, but it does acknowledge that confidentiality is not an absolute guarantee, and it notes some of the exceptions that could come into play. One is if the ombuds reasonably believes that disclosure is necessary to prevent or mitigate an imminent risk of harm to someone. That's your classic duty to warn situation. If the ombuds is, someone shares information with the ombuds now knows someone's at risk, at imminent risk of harm. There may be a duty to breach confidentiality to the extent necessary to prevent that harm. It also notes that there may be disclosures that are required by law. The clearest examples there would be a subpoena or court order, which would be binding on the ombuds just as there would be on any employee. But we follow the legal process always in terms of responding to legal documents. The next exception that's noted is, seems unlikely, but in case there were a legal claim against the ombuds can reference the information to defend that claim. So if an employee consults with an ombuds and then, say, later sues the ombuds for giving bad advice that the employee relied on to his or her detriment, then the ombuds can reference that conversation in defending that claim by the employee. That's a common exception that you'll see in other policies as well. This section also notes that if the ombuds receives information about possible child abuse or a criminal offense that's subject to mandatory reporting, there's a process for that. The ombuds is to first refer that person to whoever is responsible for making the reports under your other policies. So if it's a concern about mistreatment of a student by another student at school, that would probably be a report to be submitted by the principal. The ombuds would refer that person. You need to report this to the principal for mandatory reporting. If the person does not do so, the ombuds is then required to make the report. So we don't want any mandatory reports to law enforcement or the like falling between the cracks. There's a section on personnel records here. that says that basically to the maximum extent possible, the employee who's reaching out to the ombuds about concerns that they have about their work environment, that will be treated as a confidential personnel consultation, and any emails or records that are generated would be, to the maximum extent allowed by law, considered confidential personnel records of that employee who comes to consult with the ombuds. However, the flip side, if the employee is sharing concerns about a coworker or supervisor, let's say, the policy says that this would not be considered a personnel record of that coworker or supervisor, the person that the employee has concerns about. And that's so that that person doesn't have a right to access the communications. That makes sense? They remain confidential to the person who needs help. If you're complaining about your boss, we don't want the boss to be able to come in and see what you said about him or her in an email to the ombuds. So that's the idea there, is to have it work as a sort of a one-way ratchet. This part of the policy next notes that the ombuds will create documentation only as necessary to perform functions or as required by law, and will keep those documents confidential to the maximum extent possible. That's what I've been told by a number of people, is that ombuds practice, similar to school counselors, is not to document a lot of stuff because it's so important that we protect confidentiality that we don't want to generate a lot of records that then there might be exceptions or accidental disclosures. So they're really going to mostly be private consultations without a lot of generation of records. This section of the policy next prohibits the ombuds from responding to media or public record requests about any confidential concerns. That's what just either get referred to communications or there'd be no response. And then it states that the job description or service contract for the ombuds will identify ways that the employee may assist employees. So it's not just the don'ts. We've addressed the don'ts. The employee will not conduct formal investigations, adjudicate disputes, et cetera. But this is a list of what things they can do to help employees. And it includes listing and helping to clarify a constituent's concerns, providing information that's to constituents about resolution options, whether it's a formal grievance policy, informal opportunity to resolve an issue, so letting the people who come to their office know about their options, providing internal or external resources available to support the employee. There may be employee support programs, benefits, administrators who have expertise in certain areas who may be able to research issues. It's kind of a conduit of information, being able to refer people within the organization to other available resources. And finally, facilitating informal discussions or mediations if all parties agree to participate. And the ombuds can't force everyone to get down to sit at a table and resolve an issue, but the ombuds can encourage those types of informal resolutions. And if they don't work out, then the ombuds can tell the employee about the formal dispute resolution processes that are available. And this section also clarifies that the ombud has the sole discretion to decide which of these options would best apply in any situation. So there's going to be a lot of judgment and discretion in exercise of these job duties. There's a caveat that the ombuds will never offer legal advice or act as an advocate for any person. So that impartiality is the watchword. The ombuds is not taking sides. The ombuds is listening carefully, respectfully, and non-judgmentally, and helping suggest ways to resolve an issue without taking sides in the dispute. The next subpart of this section is about access to records. This is part 2. It establishes that the ombuds is a, quote, school official for FERPA purposes. That means that it's not unlawful for the ombuds to inspect student records that are necessary to discharge his or her job duties. So that's good. The ombuds would be bound by FERPA, could not redisclose the documents except in accordance with your policies on student records and federal law. But it would be okay for the ombuds to receive student records to do their job. It also, this section also clarifies that the ombuds may not access the personnel records of any third party, any person other than the person who's consulting with them, or really any person without their consent. So the ombuds cannot go into the HR and start digging through personnel files to check out prior. That would be a misdemeanor. So we have to be really careful about that. Part 3 is on neutrality and independence. It states that the ombuds must be neutral and independent and treat everyone with respect and consider the interests of all affected persons. It states that the ombuds must not be aligned with any associations that create conflicts of interest or even the appearance of a conflict. but may meet with such groups to explain the role and the service of the ombuds. So not precluded from meeting with advocacy groups, for example, but really shouldn't be a member of an advocacy group that would then could potentially be a party in a dispute that might come before the ombuds. And finally, the ombuds may not serve on any school system task force or committee or have an interest in the state or outcome of any issue under review. Kind of common sense, conflict of interest rules.
I'm sorry, Neil, where was that last one?
This is also in Part 3, neutrality and independence. Those are the points that are covered in that section. And then Part 4 is about access to legal counsel. So given that the ombuds would be giving advice on disputes and concerns that could very well implicate statutory requirements, other policies, and legal concerns. It could be bullying, harassment, discrimination, things like that, or the Title IX complaint. Those are the types of things that might come up. We thought it was important that the ombuds be able to get good, solid legal advice. So there's a provision that says the ombuds may contact the school system attorneys as needed. We did also think about the potential for conflicts that could arise there. Let's say the ombuds is consulting with an employee and on a personnel matter thinks the supervisor's given really unfair evaluations and is trying to force them to resign. If we were already advising the administration on that employee, we would not be the best resource for the ombuds to have legal consult. So in that case, the ombuds and the school system attorneys are allowed to consult and offer a recommendation to the superintendent and board that there be separate counsel appointed for the ombuds, if that were to happen. One way or the other, if there is a tricky legal issue to sort out, we want to make sure that the ombuds has the ability to get good legal guidance. That leads us to Section E, which is on the impact of the ombuds consultations on notice requirements and deadlines. The section clarifies that contacting the ombuds does not create any exception or extension to any legal or policy deadlines. So, for example, there might be a deadline for filing a lawsuit, statute of limitations, there might be a deadline under your policies for filing a particular type of grievance. So calling the ombuds doesn't create an automatic tolling or extension of those deadlines. Everybody's responsible for following whatever deadlines are imposed by law or policy on formal complaints and grievances. Section F, it's called limitations. It reiterates that the ombuds may not accept formal complaints or conduct investigations. It's only to assist with voluntary informal attempts to resolve concerns. You'll see that this permeates the policy because it's very important to say what the ombuds can do and can't do. Section G is about involvement in internal or external investigations, complaints, or grievances. Again, it reiterates that the ombuds may not intervene or participate in formal complaints, investigations, grievances, whether external or external. That would apply, for example, to an EEOC complaint, an OCR investigation, a social services investigation. Whenever we have a formal process, that's the ombuds steps out at that point. The ombuds' role is to provide impartial guidance to the employee who calls, not to get involved in formal investigations and complaints. Section H, withdrawal, just simply advises that the ombuds has discretion to withdraw or decline to assist if his or her involvement would be inappropriate. Examples would be a concern not raised in good faith, a misuse of the ombuds' function, they're not really asking me to do something I can do for you, or if there is a formal review process ongoing. If you've got a board appeal on a formal grievance pending, it's not a good time for an informal ombuds consult on the issue, for example. And then the last two sections, Section I is data collection and reporting. I mentioned at the outset that in addition to the individual consults, we do want the ombuds to keep the board apprised of systemic issues without breaching confidentiality as to the individuals who come forward. So the requirement here is that the ombuds, it specifically states that it's an important function of the ombuds to identify general trends, broader issues, systemic concerns. It requires the ombuds to provide quarterly reports with no identifying information that would summarize those issues. What Orange County Schools Ombuds has done, as Dr. Crane has shared, there's the ombuds reporting guidelines. That's exactly what he does. He reports in the categories that align to the International Ombuds Association. Say we had 13, it's not that many, but 3 complaints in category C, 2 complaints in category 1. He'll produce a little pie chart so you can see patterns and trends emerge. This section also says the board can request supplemental reports at any time, so you get at least a quarterly report from the ombuds, but anytime you want an update, you can ask for one. And it also says if this concerns are significant enough, the ombuds may we'll bring them to the board's attention immediately. You don't wait for a quarterly report if the ombuds is getting extremely troubling reports that suggest a trend or an issue that needs to be addressed immediately. The ombuds can escalate that quickly, again, confidentially, without identifying information, but that's the idea. And then the final section, very brief, on operational guidelines. Often you'll see policies authorize the superintendent to develop regulations. This says the ombuds will develop operational guidelines, not the superintendent, because he or she is operating outside of the chain of command. But the ombuds can develop operational guidelines so long as they're consistent with this policy and the International Code of Ethics for Ombuds. That's a summary and overview. I'm happy to take any questions.
All right, thank you, Mr. Ramey. Appreciate everyone looking at the policy. It's very detailed, but it's setting up something new, and so staff has really tried to anticipate all the different possible outcomes and set something up as a model. There was one section that I'd gotten some questions about that I wanted to ask you about. If you look at section, I guess two different sections, Section D, Standards of Practice, subsection 3, Neutrality and Impartiality. It says, the ombuds shall not serve on any school system committee or task force, and shall have no interest or stake in, and shall incur no gain or loss from the outcome of any issue reviewed by the ombuds. But particularly the first half of the sentence, the ombuds shall not serve on any school system committee or task force. And then further down in G, involvement in internal, external investigations, unless otherwise required by law, the ombuds shall not intervene or directly participate in any internal or external investigations, complaints, or grievances, including but not limited to, and then they enumerate several. One thing that I've seen ombuds do in other organizations, and it goes back to that ombuds standards of practice which we reference, is in their general practice standards, ombuds often work with organizations to identify potential systematic issues, right? So they have a standard of practice 1.3 that says the ombud assists the organization by identifying procedural irregularities and systematic problems. This may include identifying emerging trends, policy gaps, patterns of problematic behaviors in ways that do not disclose confidential information or communications. They may provide general recommendations to the organization for addressing these concerns. And so that's sort of like a regular function that many ombuds have, and I just wonder if the policy language here would prohibit that. Like if there was a role for an ombuds to serve in, a structural review or a compensation review, or if we looked at grievance or due process policies, and we'd had a lot of input, given to an ombuds, if an ombuds could serve in that role, even in an ex officio role.
Yeah, that's an excellent thought. I think from memory, I believe the language, the ombuds shall not serve on any school systems committee or task force, came from the Pasadena policy that we use as a model, for the Orange policy that we use as a model. So I don't think that was by design from staff or myself that we're specifically recommending that to you. And I think that's a good point. To my mind, it would not be inconsistent for the ombuds. I think the idea is protect against an appearance of impropriety. If the ombuds is on a lot of task force or committees that give the impression the ombuds has a point of view, that could be problematic. But it may, you make a good point, if there's not a compensation committee or employee benefits committee and the ombuds has been fielding calls for a year, about these types of issues, that might be helpful input that could. I don't see a problem with that level of participation. Do you, Dr. Crane? I don't. Based on your review of the international, I don't think that would be a problem. I think we could change the language to either take that not serve on a task force altogether, or modify it to
Even if it was like a limited role, like an
Yeah.
ex officio role,
yeah.
right, where they're not involved in making a decision, but they can see and they can advise, I think it'd be very valuable to have that input. And then, again, in part of that reporting back to the board or reporting back to the superintendent, be able to justify, where they might see trends.
Yeah, I would agree, because I think it would be important sometimes if they can look at that particular process and then be able to say that this is why I'm seeing these trends. Doesn't necessarily mean that they're involved in that particular process, but getting feedback and an observation can help alleviate some of the problems that might be arising. So I think that makes sense.
Okay, thank you. All right. Other questions or comments? Ms. Edmonds?
Thank you. In section B, the very last sentence where it talks about it could be filled by one or more school system employees, I heard clearly that it's Dr. Taylor's intention to get a outside contractor in the first iteration of this. But I really think we need to strike that altogether. We revise policies often, sometimes twice in a 12-month period, and we could always add it back in if we think it's important. But because this is a new policy and it would be a new practice, I just think, that we need to strike that. Because if we leave that in, then I see really no difference in many of our practices now with folks that are in the HR department. They're supposed to be impartial. When there's an employee complaint, that already exists, and I think this just really waters it down unnecessarily. And again, if we as a board or a future board wants to add it back in, it can be added back in.
So what you would be suggesting, I take it, is that the policy specifically state that the ombuds should be an independent contractor?
Correct.
And you could change that later?
I don't-
Yeah.
To me, it's spelled out in two different sentences, so I think it would work for the spirit of what I'm saying is just to strike that last sentence in section B, but if staff disagrees, because the prior sentence,
Well, I guess my only thought, just to clarify.
or about one and more, never mind. I see
Yeah.
what you're saying.
Yeah, because
Sorry.
that sentence says you could be either way.
I
If the
see,
board
yeah.
wants to specify that it would be an independent contractor,
Yes.
we just strike at the board's discretion and say the ombuds position shall be filled by an independent contractor. And you're right, you could revise the policy. That would just mean that you couldn't shift gears as quickly you'd have to revise the policy before you could change
Oh, I
the
understand.
approach, that's all.
Yeah, I understand that, but that is my feedback, Mr. Chair.
Let's get thoughts on this point first. Ms. Rice, do you have a response to that, or do you have another point?
I have a response to this.
Response to that, go ahead.
I would be in agreement with Ms. Edmonds. For one of the things, points that I do have, if this ombudsman is to be what we say, separate and independent, I want staff to feel as comfortable as possible to know that there can't be any influence within the district to sway how they are listening non-judgmentally of that support, so that they'll be free a little bit more to share their thoughts and seek support, and that the ombudsman also feels safe with being able to share resources that would support what they're coming and asking for. So that was in response to that.
Thank you. Before we move on, any other thoughts in response to this point?
I'm also in
Questions?
agreement with that. I'm wondering if we really want to, to stress that point, is it possible to take the language in section B, perhaps, to move it further up? So it's pretty much top of the policy, so folks don't really have to scroll through. It really takes what we're saying, an independent, outside person, building this serving as a liaison for the district. So I'm wondering, should B move up? Or how do we want to really express
Yeah.
that throughout the part? So that part is laid out very clearly.
Okay, so listening to the three different parts of feedback about that, this is on the fly a little bit, but perhaps there's a sentence here that captures that independence and neutrality that says, "The ombuds shall remain impartial and neutral and shall hold no other position within or beyond WCPSS that might otherwise compromise their independence." So what I propose is we take that sentence, do you see it in B? And we move that up to be the first sentence in B. And then the next sentence, what's currently the first sentence, although, let's see, we take out the word "although," and then the next word is, "The ombuds shall function independently from control, limitation, influence, or interference from any board member, administrator, or school superintendent." And, and that's where we put the language about being filled by one or more independent contractors by the board. And then we leave the rest of that sentence, the ombuds shall be supervised for budgetary and evaluation purposes by the superintendent on the board. So we put that right up at the beginning, that they are neutral, they are independent, they will be a contractor. Again, any contractor, you would still want supervised, right? There has to be some accountability, but we would just break that up, the budgetary and evaluative purposes. That's basically at the end of the contract. You could decide if you wanted to keep them, retain them, or go in another direction. But you're not in any way micromanaging or anything like that. But I would still keep the purpose at the beginning of the policy. Vice Chair Swanson and then Ms. Rice.
I have a follow-up to that. That last sentence that says pretty much the person will be evaluated by the superintendent and the board. That could be a potential conflict if we're only responsible for the superintendent.
Okay, yeah.
This language is saying that the board now has 2 employees that we're responsible for. So I think to make it a little consistent, I would recommend that we just say that the superintendent should evaluate this person.
Okay.
Therefore, it's not conflicted.
I have some feedback on that, but I want to hear from Ms. Rice first.
Yeah, I'm in it a little, I agree with the last portion, but I'm in disagreement with the last statement. Simply because the evaluation piece, I don't know within the aspects of our law of what we can do, which I think is why Vice Chair Swanson stated that about what the board can do or whatever is. But if the person's evaluation is coming from the superintendent and the ombudsman is an independent contractor, and we're talking about one of the words I wrote down so I could be very polite, human factors. And if we put human factors into this space, is that still not a indirect sway versus the board who is really about the system as a whole for an evaluation or what that might look like? And it may be, I don't know what it looks like. I guess that's a question for us all to ask around the evaluation piece. But I am concerned that if this person is supposed to be about the entire district, and you talk about leadership people who have to report to the superintendent, and if they have complaints or if they have suggestions and things that they're having struggles with, and if this is really for the good of all of our staff, I just think there are some human factors in there that would sway around, can I really go and talk to this ombudsman and I'm in a leadership role? And so I just want us to, one, not put Superintendent Taylor in a bad spot where he can't get the positive feedback that I think that he's looking for with wanting this position, and two, for the leadership team not to really provide their honest feedback or supports of what they need when they run into challenges. So that's just kind of my thoughts around it.
So let's build on that a little bit. I'll direct the question to either Mr. Ramey or Mr. Malone. To Vice Chair Swanson's point about the board supervising employees, bless you, I know that in some districts, we say the board's responsible for hiring only the superintendent. But in some districts, particularly some smaller districts, the board attorney is the board's attorney and really is kind of like hired, and any feedback is from the board. And in some districts, they'll have a board clerk specifically as well, who sometimes reports and is evaluated directly by the board. So is there any prohibition to an ombuds reporting, to a board?
I don't think so. Rod can chime in. From the ombuds standpoint, no. And in fact, both models are common. An ombuds who's an employee or an independent contractor. Either way, I think the board wants to have largely have direct oversight, because that person has to be outside the chain of command. The whole idea is that employees are confident that the superintendent or some powerful person at central office isn't telling them what to do. So yes, that could be done, and especially if you're inclined to make this an independent contractor, not an employee, there's no statutory issue there. That's where it would become an issue. Like, you can't directly supervise teachers, for example, because by statute there's a specific role for the superintendent to recommend their hire and their contract extensions, and the board makes the decision based on the superintendent's recommendation. That's not the case with an independent contractor.
So then, building on that, I think what I'm hearing, and I invite the rest of you to chime in, I think we ultimately want there to be accountability directly to the board. But I will also say, when it comes to like supervision, just like you can have the CEO at the top and there's supervision down the line, it shouldn't necessarily be the board that's like approving the ombuds order for pencils and paper, right? And there's administrative, ministerial functions that should, I think, go through the superintendent, but it would just be that final evaluation or renewal of a contract that would come through the board. I don't have language that specifically would capture that, but it would be more that the superintendent would be the day-to-day supervisor, but then the position would be accountable to the board. If you have some way to capture that, or Ms. Rice?
Based off what you
Yeah.
just said about, ordering logistics and things like that, I don't even know, and according to the policy that we're reading, is not even the superintendent has to say, because this person has to remain independent and neutral in order to best support what this policy is saying that it's going to do. I think if within this contract, it can be a specific person or something if they need, I don't know, an office supply. I don't know if that's going to be, because we, according to the language here, determines how much funding and things that they will get to do what they need to do. It could be they order their own stuff within the budget that is allotted, that is for supplies, that are daily supplies or whatever like that, that we're need, if we're going to talk about the example that you provided.
I was just coming up with one.
Right, and so, and if it's going to be a budget item for them, then I would think that would possibly go to Mr. Nieder's department if it's something in reference to a invoice request or something that they need. So this is the preview of what you have. This is within the budgetary means in which you have for this department. This is how you have to govern your money within your department. This is what you have to spend. And then since we're talking about money, and then to me, I'm sure my other colleagues have other thoughts around it, but this is just me sharing mine, then that needs to funnel through the direct people that handles the money and they handle their own budget because they're independent. And speaking from someone in the professional world, just like most of you understand independent contracting, you're responsible for your own stuff. Even when I'm doing a training for someone, they're responsible for paying me, but within my cost, it includes what it's going to cost when you purchase books, all the other things within it, materials, and you factor those pieces in. So that may be some things we need to consider as we as a team or we as a board look at what we're willing to give for this position.
Okay.
Just a thought.
So then, are there other thoughts, or do we have a way to capture that line of accountability back to the board? Mr. Hershey?
This is from my ignorance about what an ombuds does. Have we ever had like an ombuds come in and lay out what exactly their role would be or what they envision or how they work in a school system? Or are we just kind of making this up based on what your knowledge is? Because I've never spoken with one. I don't know if, like our chair mentioned, the day-to-day aspect of it, and that kind of threw me. So I'd like some, like, real clarity from somebody who's in this world. And I don't know if that's part of the hiring process that we go through, or who goes through the hiring process if they report directly to us and all that.
Yeah, so we've actually spoken to a specific contractor and had extensive conversations with them about how they do the service on a contractual basis. In terms of an employee, we haven't talked to a district in terms of how they do that. But based on all the conversation that we've had in the study that we've done, we know how that position would function.
And it happens to be the same group that Orange was this close to contracting with. They decided to go in-house for cost reasons at the end of the day, but it's the same group, so I'm somewhat familiar with them. I'm sure they would be happy to come speak with you. Dr. Crane and I researched, just sort of the ombuds ethics, code of ethics and stuff, and the policy reflects that. But that would certainly be an option for you all. I'm sure they would be happy to come speak with you.
The other reason I bring this up, and maybe I just need to do my own research and everyone is ready to go, and that's fine because this is a board. But I don't know like the cost that we're planning on spending on an independent contractor, so those are kind of factors, and I'm not saying that's, but I'm also hearing about how tight budgets are and how does this impact or improve academics, all of those questions. So I don't really know what they do well enough to say, well, we're going to spend $350,000 a year on them.
I don't remember,
I don't
remember the
Yeah.
quote.
I don't know what the cost is. It might be 100.
And so one of the things that we really felt comfortable about the contractor is that it would allow us to control what that cost was. And so we've had estimates
Flat
in
rate.
between 10 and 15,000. We can make adjustments based on, how the volume changes over time. And so that is one of the things that we really wanted to do as the first step, to really have that control over what the budget is. But we also recognize that that funding that we would spend if we hired a person, it would probably be about the same. But the difference is that we weren't sure of what the volume might be and if one person was going to be enough. Now, we do believe initially it's going to be low until people get comfortable with it. But at this point, doing the contractor allows us to get comfortable with the position, allow employees to get comfortable, build that position, and then if at any point we need to pivot, well, with a contractor, you can do so. But if you have an employee, now you have a person that you have to deal with as you would any other employee. The other thing I'll add is, and this is where I'm not sure from an evaluative purpose how we need to do this, meaning the board and the superintendent. I think for logistical purposes, person going on a professional development, ordering pencils, I think that's fine. I think the real question is how do we evaluate the effectiveness either of the program or a person? And so let's say we hire a person, but the person is performing poorly. How do we come to that determination? And I'm still trying to work through that on my mind, because I agree that if I'm the evaluator, then to some degree that person knows that I may have my thumb on the scale. But if they perform poorly, how do we get to that? Is that something that the board wants to be involved in? I don't know. We're talking about one person, then multiple people having to come to a conclusion about it. I'm just still trying to work.
I can share a
My
couple.
only other follow-up is just for the hiring purposes, if we're talking about someone who is going to be reporting directly to us, and this was to your question about who a board hires and fires, are you guys hiring them or are we hiring them? And therefore, when do we interview them, or would we not be expected to interview them?
We hadn't, I don't think, talked about in that level of detail. Dr. Taylor's got a recommendation in back pocket. We'd wanted to get the policy to you first because it seemed to be a little cart before the horse to say, hey, we recommend you hire this ombuds before you have a policy to govern what the ombuds does. So that's the idea. A couple of points on the cost. I don't recall the exact quote that we got, and we haven't gotten that far in the contract negotiations with the group that Dr. Taylor would like to contract with. But I think they were proposing flat rate billing, which a little bit surprised me for a district your size, because I could imagine the number of calls they would get could be anywhere between 0 to 500 a day. But I think that's what they were pitching. It's the same group that we worked with in Orange. That board decided to go a different direction, mainly because of cost concerns. Because it's a much smaller district, they were concerned about a flat rate that might be a waste of money because there might be no activity for a whole month and they'd be paying a flat rate for that month. And so we asked for hourly rates, and their hourly rates were, I think, $350 an hour. These are lawyers, they're trained ombuds, they're going to be, I think, pretty good at what they do. I would have reason to believe, but it's not cheap. So the flat rate billing is the current approach that we would hope would manage costs if you all go in this direction. But we still have to negotiate the contract details with the group.
We have a number of other questions around the table that I saw. That's just one. Did you have a quick one?
I did. I know Mr. Hershey had talked about how does it improve academics, but I think if you have a teacher who has a complaint with an administrator and went up the process and has not been able to get some sort of due justice, this is how you can improve academics, by making sure that a teacher has an outside person that they can go to that is trusted, that is separate from the district. This is, I think, a way that we can build that trust with folks. So if you have teachers who can express their grievances, receive some sort of due process, it's a win-win. The same for an administrator and anyone else. It's just ensuring that we can be as transparent and finding ways. Yeah, I didn't want that to sit out there.
I agree with you.
Matt, about everything that I've researched and read, you use the word due process, right? That's a very formal term. When we talk about due process, now we're talking about employee relations, how complaints or grievances are filed, deadlines, response times, ability to get to a board hearing or a superintendent review of decision. It really is an impartial thing. And so having someone to listen to employees and to, the bottom bit about promoting individual empowerment, self-determination, and collaborative problem solving really is, in my understanding, where the ombuds works with employees. So I gave the example during policy committee of sitting across the table from former Superintendent McNeil. At the time, I was probably a sixth-year teacher, and I had a question about something my principal did. So I asked him, and I thought, ooh, great teacher leadership. I'm asking the superintendent my question. And his first response was, have you talked to your principal? That is individual empowerment. He encouraged me to be empowered to take my concern to my principal or to my coworker. For me to determine this is the, so it's less of a employees are going to get due process and more of a how can we inform and encourage employees to take action on their own behalf with speaking with their supervisor or beyond that, and a reference to what the formal processes are within the district with regard to complaints and grievances and employee relations. But that's my 2 cents.
I guess the other way that due process could be promoted, though, is say an employee comes to the ombuds and the ombuds suggests some ways to informally resolve the issues, and then they're not successful. My supervisors, it's like talking to a brick wall. I can't get anywhere, and then it's worked. At that point, the ombuds may say, well, you do have a right to file a formal grievance. Tell me more about the concern. Oh, this would actually be a harassment complaint. This sounds like a harassment complaint under policy 1720, or this is the employee grievance under 1740. So just navigating the formal process without being an advocate, it's not like the ombuds are going to say, let's sit down and write your complaint together, but helping provide that triage and understanding of the policies that are available, I think is a very key part of the ombuds that can promote due process in the long run.
So Ms. Caulfield will do Ms. Rice, and then I'll have one follow-up.
I think you just answered some of my question, because I was going to ask how we would use this, and what do we currently use right now. I'm assuming it's human resources is where they would wind up.
Yeah, I mean, if a person has an issue, then they may talk with someone in HR and kind of try and navigate the process. If they're not able to mediate it, then they would file a formal complaint if they will. Now, obviously, the feedback to that, the problem with that is if I'm talking with a person in HR, do I feel they represent the interests of the district more than they do me? And so that's, I think, probably what you all have heard more than anything, an employee that has an issue with their supervisor. And they believe that if they talk to HR, HR is really there to support that supervisor and not them. Now, that's not the case. What they do is look at each individual case and really, they fall on the side of what's correct. And it may be supporting the employee saying that you're correct, or it may be saying, well, I'm sorry, your supervisor is correct. But that is still really about perception. So this process allows that ombuds to be able to engage with that employer, with the employee, to help work through that situation, so it may not end up in a formal grievance process. I think what we find is that when people have an opportunity to talk through it, then they can resolve the issue and not get into a formal process. But that, I think, has been the biggest issue, that we do have a process, but a person feels they really do represent the district and not me as an employee.
Okay. So I guess my question is kind of like a three-legged one, or maybe one answer. Do we have examples of other schools that have used it and how it has helped them? Or if this is new? And how many complaints do we get, like, say, for example, per month to warrant something where we would need an actual example? And how would we triage something like you gave an example of pencils versus, somebody complaining about an employee that we're not spending $350 an hour for somebody to say, I don't like the supplies that are in the classroom. Like, how do we triage that to know that they're getting what they need, but we're not paying for something that can be handled with the proper direction, where it isn't really something to triage?
So one quick point is that the current plan would be, and certainly Dr. Taylor will update you, maybe our plan is to get the policy, ready to go, and then very quick contract negotiations with this group and bring you a contract. We would get the pricing then, but the current plan is flat rate pricing, so it would not cost you extra if the ombuds got even a frivolous complaint or two and had to say, well, I'm sorry that you don't have as many pencils as you like. Maybe you could ask your supervisor for more pencils, and then, that's not going to be billed at an extra cost. That would be flat rate billing. It is a fair point if it's per hour. Then I think we need contract, and David Nieder wants to speak to this. I think we would need some contractual limitations on what the ombuds could and could not charge you for. That would be a part of the scope of services.
Mr. Nader, did you have a comment? And then we'll go to Ms.
I
Rice.
just want to make a comment because I do believe at this point it's important. While the district superintendent, myself, and a few others have spoken with a potential vendor, it's just that a potential vendor, once a policy is established, we intend to put this out to RFP. We will let that one contractor know that it's going out to RFP, but we will take every potential vendor that is interested in submitting a proposal to us. And it's not really an interview when you're looking at it from a contract perspective. It's really an RFP review process where a rubric is established, and then based upon whatever is in the rubric, price would only be one thing. It's a service contract. We're not required to go with the lowest price. That would be a part of the decision-making process. Funding is also yet to be established.
All right. Ms. Rice?
Thank you. I'm glad Mr. Nieder brought it up because that was kind of my question here. It sounded like, thank you for using the word proposal, because it sounded like there was already a decision made and then we were just left to decide.
I think that was my mistake in
That's
forgetting
okay.
a conversation I had with Mr. Nieder and Dr. Taylor.
Well, no, it wasn't just you, Mr. Nieder. Both you and Superintendent both said, hey, we've already talked to this group and
Yeah.
stuff, and so it just, we're listening to understand where you're coming from. The other part that I think that Mr. Nieder shared, I still do have a concern with it just simply being an RFP, because then it still takes it away from the hands of the board to decide these contractors. So I don't know what that looks like.
It would be your decision. You would select the contractor, and you would essentially supervise the contractor. I think that's the basic idea, is that, we could get back to the details about budgetary issues and, to what extent do you want the superintendent to be able to manage the independent contractor relationship without your guidance. But I would say hiring and firing, those would be board decisions, right? I think that's essential to keep the person outside the chain of command and preserve the impression for employees that this person is not afraid of losing his or her job because of angry administration.
Yeah, so that was primarily my thing. I really want, for me, I really want to stay within the language of this being an independent person. For me, it is important in order for, I think I understand the intent of this ombudsman, and the intent of this policy is to improve our well-being relations within our district, to improve the culture of our district, to make sure that everybody has good working conditions and can do our best to Vice Chair Swanson's point around student achievement. When teachers are okay, students can be okay. I greatly believe in that. You guys know I believe in well-being, but I really want us to keep a pulse. I don't know how everyone else feels, but I really want us to keep a pulse to how this plays out. And I'm really just listening to understand, and just listening to language that we're prematurely, as some said, using, that this stays within the board's purview of how we move with this because of the intent, I believe, of the policy, and that it doesn't get away from the 9 people around the table. Those are my only concerns.
Thank you. So actually, what I'd like to do, because we do have limited time, we do have another policy, I will come back to you. But I want to provide just a little more context with all of this feedback. And I think, Mr. Ramey, you've heard the board concerns, you've heard suggestions for edits here. I want to give you all a little some historical context that the district had approved the creation of an ombuds position under the previous superintendent. But one of the challenges was that there was not a lot of clarity about what that position would do. And it would be someone who would be here. And it was even posted, and we had applications. And, you know, we had principals applying. We had people that really did not have experience in dispute resolution applying. And it was ultimately decided for us by budget issues that we could not bring in someone of that level at that time, and so it sort of languished. And so with the concerns that have been brought to us about, by employees and others about HR concerns, this ombuds model is something that has worked well in a lot of states and in a lot of different school systems. But what we ran into is trying to learn from the lessons of the past. It was sort of a chicken and egg thing. We wanted to be able to bring a policy first, rather than trying to say, okay, here's an ombuds, now let's figure out what they do. The idea was to bring the ombuds first, so then different people that provide that service can be kind of matched, what to put in an RFP. And so I want to direct everyone to the core values. And these are the things that, we're just based on like Chapel Hill's model, the California model. I will say that, knowing what Superintendent Moore had gone through, I was able to tell Dr. Taylor, if you want to do due diligence, here are some large providers of these services in the Southeast. And so if you're looking for someone that represents these core values, call around, right? Because the other thing is that even if it does report to us, we'll still need like a budget estimate, and it'll still need to come to us as a recommendation in the superintendent's budget. And so, I did ask him if he was going to bring the policy to look at, one, the independence, the contractor versus the employee, and to look at cost. That was something that he wanted to recommend. And so one of the things that we've identified is with the idea of a contractor, you also have the independence, but you do have that scalability. And then if this process works, we can always evaluate. If it doesn't work, we can scale it back, we can cancel it. But if it does work and it does show improvement, and the board in evaluating it decides that this is a good tool for the district, many districts have this same function not just for employees, but also for parents and students. And so we would have a good model. And again, just in terms of cost control, we can see the benefits. And then when you make those hard budget decisions, you can decide, is this service, just like trying to decide between a counselor and a nurse, or, another teacher in this field versus, an administrative position in that field. You'd have real practical experience to base it on. So with that, I hope if we can get a policy that has everything in it that people want, we can then go forward from the policy and see then who or what we hire. But having the policy helps us know like what we're going to do and who we can look for. So I'll do Ms. Caulfield, Ms. Rice, and then if there's no one else, I do want to end this item and then move to the next item on international exchange students before our work session time expires. Ms. Caulfield.
I was just going to ask, since it is developing and we're talking about proposals before we even figure out what the contract's going to look like, that we have options. Because oftentimes we just receive the final thing to approve without knowing, well, what was the other option before we approve this one. So,
Yeah,
I think
like
this
we would get
this
a
would be a
pool.
this would be a different process. I think you wouldn't get just a recommendation to hire this company. You would get probably the proposals of anyone who responds. I would say in Orange, they got 3 responses to an RFP. There are not that many organizations that provide, that are certified ombuds and provide ombud services per se. A lot of lawyers will do this kind of work because it is kind of illegal, a little bit of illegal or quasi-legal work. But I don't think there's that many, in the area, there are not that many ombuds groups. So probably, I would anticipate you'd get 2 to 5 proposals would be about what I'd expect. And I imagine those would all be in the materials for you to review.
And Ms. Rice.
One, with that, with the RFP that we're coming out, are we only saying that these people can only be a certified ombudsman? Since you just mentioned that it's typically lawyers who are, and I just, lawyers seem to be kind of.
Be careful.
I appreciate you. Pretty much, you know how to keep it in the road. I mean, I appreciate, which is what are pretty much fair and impartial. You go with what the facts are, and that's the boundaries in which I'm saying that you stay
You don't
within.
need to be a lawyer to be an ombudsman.
Right.
They often tend to be. The group that had a proposal for Dr. Taylor, I know because I checked with them, their ombuds are attorneys also. But that's not necessarily the case. And,
Right.
Yeah.
Right, so I just wanted to see if we limit but not limit, because so we can get a good group
Yeah.
of people, because we also need people with a pulse, so to speak. The other thing that I had a question was, oh my God, I'm old. Oh, it was about funding, it was about finance. Now I'm going to have to ask you later. Because we're tired and my brain is gone.
Just to build on that, though, I know Mr. Ramey said that most of them tend to be attorneys. The key skill anyone qualified for this work has to have is dispute resolution.
Yeah.
And that was the problem with the previous process. And there's like references in here to documents that aren't necessarily provided in Assembly, but like the International Ombuds Association and their standards. And when you go to that, you will find there are many thriving ombuds practices, just like mediators, that aren't necessarily lawyers. So, because it has not been as big a practice in the South and the Southeast as the North, the Midwest, and the West Coast, there's not as many offerings here. But the dispute resolution is the key.
I remember.
Okay.
If it's okay, really quickly, I know we, just as an example, we're using about the firm or the practice, $3.50 an hour, and they set a flat rate. I do at some point want to come back around to that if we can, because my only concern is we have 20,000 employees. And so,
That's a lot.
and I know we're talking about a group, which means we're talking about a practice, which is not going to be necessarily one person, I'm assuming, if they're in this group.
That's right.
So it's a round table of folks,
Yeah.
which is a little concerning too, but versus one person developing relationships who can actually monitor trends versus whoever's available within that practice to come and make an appointment. So that was my concern around the funding and the person, and what does that look like dealing with 120 employees and getting people on a calendar to be able, so those are logistics, but I just wanted to raise that concern a little bit for me, and the concern of having a firm versus a person that can't monitor like that.
And I think if we could approve a policy, then we would come back before there was any RFP or selection with like a work session to really dig into some of these issues, have maybe presentations, even if it was someone that was disqualified from bidding, but someone who could come in an educational role and say, look, I'm not pitching your business, but I can tell you what an ombuds does, All right, Ms. Edmonds, and well, this will finish it up.
Just procedural, do you envision this coming to policy next or another work session first?
So.
Or had you thought about that? I don't mean to put you on the spot.
Yeah, no, it had been the policy.
Right.
I was hoping that in work session, if we could get it to where we were comfortable, then we could bring it to, we could have any amendments incorporated. It sounds like we've got some language we like incorporated, but then we could just bring it back to like a board meeting in January for discussion.
Okay.
If that meets everyone's,
Want a motion then?
So
I would
do you-
entertain one.
So you would want to not bring it back to policy, but bring it directly to a board meeting for first reading? For the amended language in first reading?
Well, that's a good point. Does anyone have thoughts on that?
I think that this conversation about this needs to stay at the board table in session, even if it has to go a couple of rounds of sessions. We just slated for 45 minutes to an hour max. I'll take my questions. But I think it needs to stay at the board table. I don't think it needs to be, in my opinion, in committee. I think this is a conversation we need all of us to weigh in on as it comes versus being in committee where you can come or not come if you desire. I think, yeah, just to limit the confusion.
Especially if it's going to be a board responsibility.
Yeah.
All right. So are we good with bringing it back to the board for a first reading, or are there any procedural issues that we would have?
Well, for I think we got some good feedback on some restructuring and moving some pieces in Section B. What I'm not entirely clear on is where we landed on there's a phrase that the ombuds shall be supervised for budgetary and evaluative purposes by the superintendent and board. Did you all want us to revisit that?
I think just sort of separating a little bit,
It
like
was just supposed to be board, I thought.
that
Just remove
it would
it.
mostly be the board, understanding that there would, they're not going to send any expense stuff to us to sign. It would
Right.
So you want us to come up with something that
Yeah.
would give a more limited and prescribed role for the superintendent, but with the board providing basically the supervisory function.
Yeah.
But what do you expect from the superintendent? I would think that you would want to invite the superintendent's input. Hey, I got to tell you this, I'm getting
Yeah.
complaints about the ombuds, you should be aware. That would be helpful information from the superintendent. It doesn't determine the outcome, you determine the outcome. So that might be an evaluative function, but ultimately, in terms of whether to do a contract, for example, the independent contractor, that's the board decision. Is that about where the
I think
line is?
it's about the selection and
If he
evaluation.
shares his assessment, which he should.
Right.
Right, within the analogy that you just
Right.
gave, if he shares his assessment, and then, of course, ultimately, it's the board's decision.
You'll make the decision what to do with the
Right,
contract. So
and
I
the
think that's-
evaluation of it based upon what the
Got
superintendent
it.
may share, if he has any at all.
Yeah, I think that's helpful. I think that's enough that I think we've come up with something that hopefully you'll like, or at least would be close to, that we can massage at the next meeting.
All right, so is there a motion?
I make a motion that we accept the ombudsman policy with all the necessary corrections for first reading.
All right, thank you. Is there a second?
Second.
We have a second, a motion from Ms. Rice, a second from Ms. Edmonds. All in favor of the motion, please say aye.
Aye.
Is there any opposed? All right.
May I clarify a date on that?
Yes.
That would
No,
be,
to go to first reading.
To go to first reading.
it's going to go to first reading. Let me get my calendar up here. And the first meeting, the January board meeting will be,
Any of them?
I think it would be best to just coordinate with Melissa, Ms. Allen, to figure out when the next board meeting would be.
okay, will do. Thank you.
Yeah, there's still a lot of things in play that we may not be able to decide right at this afternoon,
And it would be on action.
but only on first reading, so
Right,
whatever we
right.
did would still have to come
Right.
back for another opportunity for discussion and a vote.
Great.
Okay?
And that would go to policy committee.
No, it wouldn't go to policy.
Okay, gotcha.
Yeah. Okay. All right, at this point, it's a little bit after 3:45. We have international exchange student policy. We'd allotted 30 minutes for it. Dr. Hill, do you think? All right, I appreciate it. Thank you, Dr. Crane, we appreciate it. Thank you, Mr. Ramey.
I'm actually going to stick around because it might be some immigration issues here that I might want.
Same.
All right. Welcome, Dr. Hill.
Good afternoon to everyone. I understand at the last work session, we wanted to bring this item back, and so Dr. Crane has really and truly been helping to guide this conversation as we look at Regulation Code 4100 regarding our international exchange students. And I'm going to ask Dr. Crane to kind of lead us through this discussion. And we do have our international world language
Come on up, Chief.
with us today for any questions. So we're going to have this conversation now.
Sure. So just as a foundation, we do have policy 4100, which is admission to the Wake County Public School System. And in policy 4100, in section D, item 9, this is, under this section, section D is admission based on exemption to domicile requirement. So our internet, number 9 says that foreign and exchange students who are participating in exchange programs approved by the system.
Hold on, Dr. Crane.
Sorry, Dr. Crane, we don't have what you're looking at.
You're right, you don't, and I'm just reminding you that the policy, the superintendent or designee is authorized to develop criteria for admission of foreign exchange students and to admit foreign exchange students according to those criteria. So the policy on admission provides for students who are not domiciled in an exchange program, international exchange program, to attend as established by the criteria that the superintendent designee developed. The criteria is attached to your to the Assembly posting, and that's 4100 RMP, international exchange students. This is the criteria that staff use to operate the international exchange program. In it, you will find that in section A, the district has to approve the organizations that we work with and what those criteria are. We state in section B the responsibilities of those organizations. In section C, we outline how we accept those students and the criteria there. And then in section D, we talk about how we place them. Section E, any special agreements that we might have. I understand Mr. Swanson has a concern or an exception that he might recommend that we consider. So we brought the RMP with us today just to hear what your concern is and how we might address that.
And with that, Vice Chair Swanson.
Thank you. I know that Mr. Cook is enjoying his retirement, but I know he was very instrumental in helping with this situation that arose. And so there was a situation where a host family had a situation where they could not necessarily house that student anymore. And because it went past that July 31st deadline, our hands were tied. We could not necessarily do anything to support that family. And so given the fact that our policy has that harsh deadline, is there a way that we can come up with some situations where we could have staff approve that if there's some dire hardship that's similar to our other policies, that we could approve this, given the fact that we have these host families, something may arise, and it's not their intentions to not be able to house a family, but we don't want a student to fall in a situation where they don't have the support that they thought they were going to have. And so that was the piece that we had experienced, and was hoping that we could bring this to come up with some remedies to assist our students and families.
We have in section C, when we talk about acceptance, we do have this kind of criteria. So in the introductory paragraph, and yes, I do have Mr. Cook and Ms. Delinda on my shoulders here, right? We do have that we only accept for year-long course of study or a first semester only. We don't do second semester. And we do not accept exchange students as transfers from any other school districts inside or outside of North Carolina. So if we're looking at a student who had a situation fall through in any other district in North Carolina or outside of North Carolina, we already say in the very beginning we do not accept that. So if you want to make an exception to that, we could put under extreme circumstances, et cetera, we could put a notation there.
We would need to review whether you can do that, because I think that this is about a student exchange program, so these are students on J visas that are sponsored by so the Department of State issues the visa, and it's with an approved exchange program to attend a particular school, usually, so, or at least a school district. Yeah, so I think that could be problematic. We would at least need to research it to say, I'm not sure that you can take an exchange student who's got a visa allowing them to attend school in, say, Johnston County, and say, we're going to enroll and attend school here. Maybe, but I don't know without checking the federal regs whether you could do that.
I think the piece I was concerned about most was that July 31st
Yeah.
deadline. And I'm not opposed to the piece
Yeah.
that you just raised,
Yeah.
both Dr. Crane and Attorney Ramey, but just really that deadline, if it could be extended or giving staff a little bit of leeway, that not, accepting students the day of school, I don't know what that what that would put the schools in those situations, but at least extending that a couple of days or whatever seems amenable for the board.
So in item number 2, in section B, it says that the students must apply for admission to the system between April 1 and July 31 of the year in which the student wishes to enroll. And then it talks about that process. Then over in section D, we say,
C, that's section C.
sorry, section C.
Is that the date you're talking about, that July 31st? Okay.
In section D, number 1, we have a sentence that says, seats will be filled upon official review and acceptance of the student application in the order in which they are received.
We don't see that.
Top of page 4,
D1.
the last sentence in D1,
Okay.
In the policy, right?
in the RMP.
In the RMP, okay.
So we have, one of the concerns that Ms. Ramirez Carter mentioned was many schools with seats are filled on day 1, April 1. So we begin to say no to certain schools on April 1. Things fill up. And we have said no after, up until July 1, we've said no for this school, no for this school, no for this school, for scores of students who may want to attend there. And so if we take an application after that fact, after the deadline, then the order in which it is received is still at the very end of the process. And should we consider any of the other no's that we have said, should we be offering any of those the same consideration? And again, just we don't want there to be any inequity as far as opportunity is concerned for students who have already been told no, and then a late application comes in, other things have fallen through, but we did not go back through that list of no to see if they wanted, do you want the spot now, kind of thing. That was a concern that staff had mentioned. Again, I do think, Mr. Swanson, if what you're most concerned about is in item number 2, we could add a phrase at the section C2 at the very end to say requests for acceptance after the July 31 application deadline may be reviewed and considered at the discretion of the superintendent or designee.
I'd say pending review of the federal regs, though, again, because there may well be federal deadlines for when these things have to happen. I don't remember I think I worked on this policy like 15 years ago, or this RMP when it was first developed, and I don't recall, but I think those dates may be set in order to make sure that the school district can hit some compliance deadlines in terms of registering for the SEVA system. This is a federal system, you have to register, and there are a number of deadlines we can't control, so I think we just want to make sure that we're not running afoul of that.
And that is also set out by the organization, so they know
Right.
what the Department of State
Right, that's true.
regulates. But I think July the 31st is the deadline.
What's the deadline?
The 31st, July.
For which? For registering in the SEVA system? Okay.
Yeah.
Yeah, so I think we could explore that between staff for programmatic reasons, and we could look at the federal regs, see what could be done there.
Quick follow-up, Mr. Swanson, Vice Swanson, and then Ms. Evans.
So I'm wondering, is there ways, because in the situation that I'm referring to, and I think all of us were included on those correspondence, what happens when the families go directly to the school and the school says there's room? And, so how and what can we put in this RMP to make sure there's clear expectations? Because if our policy says one thing and then the school is saying, we have room, we can accept it, we don't want to create false promises that we can't necessarily fulfill. So that is a concern that I have, that how do we strengthen that so everyone is on the same page? Even if we can't do a grace period, that's a concern that I have.
One thing I can share, Mr. Swanson, that may give some context on this, if a student comes to a school and to register, and there's no reason to, nobody asks for immigration paperwork, right? That's a clearly understood rule across the district. It's because of Plyler v. Doe, the Supreme Court case. You can be undocumented, and that's legally irrelevant for public school purposes. So it's possible that you have some students presented for admission with a caregiver that's coming to enroll a child, and staff at the schools will know to call student assignment, and student assignment would know there are statutory affidavits where, if your parents have abandoned you or they're unable to care for the child or whatever, you can check the boxes and the child can be enrolled based on the caregiver's domicile. So it's possible that some kids are getting in that way, even if they're in violation of their visa, and that would be a private issue, but I don't know enough. I guess I'm not sure. I'm not sure if that's even responsive to your question. I'm just saying it's possible that you could have students that aren't coming to you as exchange students to participate in a district-approved exchange program that may be enrolled because there's nothing unusual in their, as they're presented, with their caregivers for enrollment, and that would just be handled by Policy 4100, not by the RMP. I'm not sure if that's muddying the waters even further, but.
A little bit.
Yeah.
Yeah.
So your question was, how do we strengthen any language in the RMP to prevent a student perhaps going to a school or an organization or a family going directly to a school to ask, hey, do you have room? If I can make this happen, do you have room for this student? So how do we?
Because if that's the case, it's a clear violation of our policy.
Yeah,
And
I
so,
think the first thing would be to reaffirm to any school that if this is an enrollment request, then they need to go through the normal process, meaning that if I move and, ABC school, Apex Friendship is my school, and I go to enroll, they said, well, you have to go to Baltimore because we're full. There's an enrollment process, and so we wouldn't want the principal to say, well, okay, kid left, and now I have a space, knowing that the kids who are overflowing at Balcom should be on that list first. But I think here, we're really talking about exchange students, and if something happens in their process, that we're able to go beyond the deadline to accommodate them as exchange students. And so I'm comfortable with that. The regular enrollment process, I think it is about making sure you go through student assignment and not violate any board policy. But for an exchange student, if something happens to where we've got to pivot, then I'm okay if, as Attorney Ramey said, in terms of federal policy, as long as we're within that, it allows us to do that,
Yeah, I think I see what you're saying now, Mr. Swanson, looking at these two things together. It's just, you just want more urgent, if there's more flexibility on the deadlines, let's give it. Let's not just create an arbitrary deadline. And then I think there's two answers to the question which we'll need to come back. One is, for practical purposes, you need time to process the applications, get them in with the Department of State. And the second is there a federal requirement? So that, absent one of those.
I think my biggest concern, I hate to monopolize all the time on this, but I think my biggest concern is there a way that we can offer some grace period if something happens, so we can at least ensure that if students have a situation that was not cause of them, or something fell through, or it was an unnecessary burden, that a student is not in a country that they do not have the support, how can we support the students and make sure that they're here to do what they are trying to do, which is get in that experience the American education.
Yeah.
So if that means that we can put in the policy an extension or a grace period that meets these certain hardships, I'm okay with that.
Yeah, I think that's absolutely appropriate. If something happens that's outside of their control and they've gone through the process, then we do want to be flexible to be able to give them an opportunity to attend. And so as long as, at the end of the day, if they haven't done the J-1 visa process, there's nothing that we can do anyway. But I do like the idea of us being extremely flexible if something comes up. I think that's very appropriate.
Ms. Emmons, did you have a?
I do. I just wanted to follow up. Dr. Crane was given the example of having a school that's full, and we've told kids no. Were you specifically talking about exchange students being turned down because the school is full?
Correct.
Not just generally,
No.
this high school is,
No, we're
Okay,
talking
okay.
about specifically about exchange students who may have wanted to be at one school,
Right.
with a family at one school, but that school filled up, and so no more seats are available, and then the next school and the next school, and then once all of those slots are filled, we're done. We say no to everybody else, and then someone has an emergency, and something may have happened at any of these schools for one of those spaces to open up.
right.
We've said no to so many exchange students who wanted to be a particular school. How do we kind of reckon with the no's we've already given with, equitable application to someone who is in an emergency? And maybe the answer is the emergency is already in inequity. I don't know. It's
Yeah.
Well, as I say, we've really reached the end of our scheduled agenda. We do have some closed session items we need to get to, but I wanted to just ask where we are on this. Is this something that we have a proposal to amend the policy, or is this suggestions for reform of the RMP that direction has been given to staff? I just kind of want to bring back full circle on what you want our next steps to be as a board. Ms. Rice?
For me too, I wanted clarity in the question that Vice Chair Swanson was asking, that are we able to give the families grace or no? I think that needs to be clarified in the RMP in saying where possibly language. An extension may be granted. And then, going through whatever the proper channels are, which would be our staff, attorneys, or whatever, so that we're not violating any federal laws or things of that nature. And the only other question that I had is, how many, if we have it on hand, if not, it's okay, how many of our foreign exchange students are we even, that we host annually anyway? I was concerned about that, to know at least the number of the types of families we may be impacting.
Okay. So at this point, we are over time. If you all want to continue discussing, we can bring it back to another work session. I'm happy to continue the conversation. Or, Vice Chair Swanson, I know you had brought this up originally. Do you feel that, and Ms. Emmons, I'll come to you, but do you feel that this is something that would require either a policy change or an RMP change?
I think depending on what the federal laws give, what it looks like, I think it's a both and scenario. And I'm happy to lean to Ms. Evans to figure out if we can bring this to policy to make those suggestions once staff has done their research on
I
it.
think that the deadline is only in the RMP right now, so if we could just have a little time to check the federal regs, make sure there's no practical reason why it's important to have a strict deadline. I'm not hearing any philosophical objections to being more flexible if there's nothing in the way of that, so we could report back and that Dr. Taylor could change the RMP and just report it to the board anytime.
And Mr. Chair, I add one more thing, that if we're talking about the deadline, now, what I'm viewing that as a person wanting to be admitted
Yes,
to
apply
Wright
for
County,
admission.
and if there's a reason that we can extend that, it's fine. But if they are already admitted and now they want to go to another school, then I think they absolutely should be subject to the same thing that everybody else is subject to. But this is about just admission to the district.
Yeah.
So, and I like the flexibility for that.
So let's do this. If we've gotten sufficient direction, let's bring this back to a future work session just to check in, let everyone see it, see what the solution is, see what our comfort level is, and then whether it's RMP or if you all do want a policy change, we can make that decision from there. Okay? All right. Thank you, Dr. Hill. All right. It is 4:08. We are 8 minutes over, but we do have a couple closed session items that we need to get to and still stay on time for our annual meeting. Ms. Evans, do you have any last thoughts on that policy before we go?
You basically said what I was going to say, is that whatever is needed, I'd look to staff and council to tell us if it's both and or just RMP.
Perfect.
So you.
Perfect. All right, thank you, Ms. Evans. All right, Mr. Hershey.
Motion to go to close to consider confidential personal information protected under GS 143-318, 11A6, and 115C-319.
We have multiple seconds. I'll go, Ms. Gordon?
No,
Ms. Rice?
Ms. Rice.
Ms. Rice. Motion from Mr. Hershey, second from Ms. Rice. All in favor of moving to closed session for the reasons stated, say aye.
Aye.
Any opposed? All right, we'll give a minute for the room to clear, and then we will reconvene in closed session.